Welcome to Know Your Hires, creating a comprehensive screening process. I am Mike Coffey, President of Imperative Information Group. We're a background screening company based here in Fort Worth, Texas, but we serve clients all over the country. And this whole webinar series started out as a single webinar, the remnants of which you'll see today. It was kind of just a big overview webinar about background checks, and over time it grew, and as we tried to cover more and more stuff, it became unwieldy, and now we've got a series of 6 or 7 different webinars we do over a 6 or 7 month period. But today we're going to talk about a large, just kind of a big overview of what I as an HR guy think a real screening process ought to look like. And I am an HR guy. I've been in and around HR for 20 plus years. It's what I cut my teeth on, and when I had a real job before I owned this company, this is what I was the HR guy. 16 years ago, we started this firm, and it started as an HR consulting practice, and one of my first clients needed some help with background screening, which is something I'd become an expert in from your side of the desk, and we helped them, and now the rest is history because, you know, we're almost all our revenue comes from background checks, but I'm really lucky that I still get to spend most of my time working with clients about all kinds of HR issues, mostly around selection or employee relations issues. Don't call me for comp and benefits help. I'm not your guy. Or to write a handbook. Probably not good there either. But for, you know, if you've got a manager who can't keep his hands off the employees, you know, anything like that, I love that stuff. That's what I get to do. And I also help my clients work out a lot of their selection issues, both around background checks, but in a lot of other areas as well, because quite honestly, I've always been intrigued by everything from assessments to job postings and interviewing processes and all the different components of selecting your next successful employee. So that's us. Today we're going to talk about a whole screening process, not just background checks, because quite honestly, as soon as you start talking about background checks being your screening process, I really want to suggest you've already failed, because the background check should be the last thing in your screening process, not the first. And so we're going to talk about a lot of the different issues surrounding that, what we consider to be a really good screening process. A lot of that does have some impact, or is impacted by legal issues, both laws and regulations at the federal level, state level, and in some cases even local municipalities. So we'll talk about some of those things. We'll also get into the employment application, because I think that's really an overlooked tool to really, and it seems obvious, but it is overlooked by a lot of employers as a screening tool. Your criminal history inquiries, what can you legally ask, and when can you ask it, disclosure and authorization stuff that's required by the FCRA and some state laws, and the whole process of from the time you order the background check to the time you make a decision and communicate that to the applicant, what your process looks like. What we're going to do is take a really 50,000-foot look at this whole process. I've got webinars that cover each of these other elements. So you're not going to walk away today with a bunch of detail that you can go back and implement, but hopefully you're going to walk away with a lot of things to think about your own process. And if you don't want to wait, and at the end of the webinar, we'll show you the schedule of all the rest of these webinars in this series, and they're all free and approved for SHRM and HRCI credit. But in the meantime, if you don't want to wait for that, a lot of those webinars are already pre-recorded on our website, or you can just give me a call and I'd be glad to visit with you. I spend a lot of time visiting with HR pros. So let's jump into the big law that everybody thinks about is the Fair Credit Reporting Act. That's the law that governs employers' use of background checks or any information purchased from a third party about your applicant. It really ought to be called the Fair Consumer Reporting Act, because it's not just about credit. It's everything from criminal history to employment verifications, all those other things that you purchase from third parties and to use in an employment decision. Those are consumer reports under the law, and the entire act would apply. And so if you're using the report to look at credit worthiness, credit standing, but also the person's character, their general reputation, their personal characteristics, or their mode of living, those are all items that would be impacted by a consumer report, and the FCRA would apply. So when we're talking about employment purposes, we're talking about the FCRA's governance of this information when it's used for employment. And so certainly we think about the help wanted ad when you're going to hire somebody and it's a new hire. But under the FCRA, the term employment purposes includes employment or promotion of the individual, use of this information to review them for reassignment to a different position or promotion, or even keeping them on board. We have had clients who, when they were getting ready to start a layoff process, part of their consideration was, how did this person do, what was their last annual background check? Were there any criminal issues that were not maybe terminable? We weren't going to terminate this employee, but given the choice between keeping somebody with 3 theft by checks in the last year and a half over an employee who doesn't have those kind of issues, who performs at the same level, maybe it makes sense. And so anytime you're using this information to make any kind of employment decision, the Fair Credit Reporting Act is going to apply. The FCRA is a really easy law to comply with, but it's a very easy law to get sued for too. And the plaintiffs' lawyers have discovered the law in the last 5 or 6 years. And you see these amounts. The average FCRA class action settlement is $3.1 million. We're going to talk about some of the requirements of the FCRA as we go through the entire life cycle process here. But I just want to really make sure that you understand how important it is that you're 100% compliant with the FCRA. And given that, let's fire off our first poll just to kind of get your feedback. How do you think your compliance with the FCRA is? So if you'll give me a real quick rating here, we'll look and see what you think, how you think you're doing. And if you're my client, I promise I won't call and scream at you if you're not compliant, but I may call and say, hey, how can I help you? Okay, I'm going to close that in just a second. Good, okay. Let me share these results. You'll see that about a third of you say you're 100% compliant. You feel very confident in it. That's great. 2/3 of you, though, said, well, pretty compliant, stuff may fall through the cracks, and that's not uncommon. But you can put things into place, especially partnering with your background screening company, to make sure that they don't fall through the cracks, or that it's really hard for them to fall through the cracks. Because quite honestly, it just takes that first person talking to a plaintiff's lawyer because they don't think they were treated fairly under the FCRA, and the plaintiff's lawyer is going to go look for any other areas where he thinks that your process is not compliant, and he will be able to put together a class action. That's what they really love to do, and that's what all these lawsuits we've been talking about under the FCRA the last several years have been. They've been all class action lawsuits. I also want to jump in here and talk real quick about the EEOC. You can, there are a lot of myths out there, some of them promulgated by the EEOC, but a lot of them promulgated by either legal blogs or just things that somebody told you at some point about what you can and can't do with regard to using somebody's criminal history. But the EEOC has paid a lot of attention to background checks for the last really 7 or 8 years, and they published a new guidance in 2012 concerning employers' use of criminal history information. The idea is that while being a former offender, criminal offender, is not a protected class, your use of criminal history may adversely impact people in a protected class, and if it creates a disparate impact, you've got to have a business justification for the reason for all your criminal history decisions. And the EEOC's guidance is a great primer on the use of criminal history, but at the same time, I think they jump the shark a little bit on some of the things that they say they expect to see employers do. But we've got a whole webinar just on that topic. So, you know, the main thing I want you to know there is that there are a number of lawsuits out there from the EEOC. The good news is the EEOC has lost every case so far. In fact, no plaintiff has won a case against an employer, a Title VII case, against an employer for the use of criminal history since 1975. That was the Green versus Missouri Pacific case. So as much discussion as it gets, there aren't that many cases out there, and the EEOC has lost them all. There are two active ones now, BMW and Dollar General, and we'll see how they proceed, you know, and what the real facts turn out to be in the cases. These are really hard cases for the EEOC to prove, so you know, we'll see how it turns out. But what their concern is that they believe that maybe employers aren't being conscious enough of the relationship between the criminal offense and the position and how long ago that was. Those things were discussed in the Green versus Missouri Pacific case in 1975. They're called the Green factors. And you want to look at the offense and how it relates to the job and the risks associated with that job, and the actual time that's passed and what that person's done since that time. But one great tool you can use are these tools we've developed with our clients to kind of say, for this particular job, these are the kind of offenses that we're concerned about. And we've got a whole webinar just on using these tools and developing your matrix. It says, so these kind of offenses you know, are particularly of concern. And so some of them may in and of themselves simply prohibit somebody from taking a certain kind of position. For instance, somebody who had a DWI in the last year, you're probably not going to make you know, your next hotshot driver to, you know, run errands or deliver supplies or whatever. But you may say that that guy who has a DWI 4 years ago, we're not going to eliminate him from consideration, but we're going to look at everything else that he's got in his background and what else he brings to the table, and compare him to the rest of the applicant pool and say, you know, do we have similarly situated applicants with similar skills and background who don't have this this kind of history? And then you may say the guy with a 15-year-old DWI, we don't even care about. We don't care about that offense. And these tools we have that we share with our clients and we cover in the webinar help you get to that place. And so I would really recommend that if you don't have something like this, that you look at it, because it's really expensive to hold on 2 seconds. I'm looking at my notes here. I try to keep up with the notes that are coming across, the questions that come across, but I will answer all the questions at the end. So I'm going to fire off a real quick poll here because I'm curious about how prepared are you for a discrimination claim concerning your use of criminal history? If you'll take a second and give me a response there. Okay, good. Okay, I'm going to close that and share those results. So about half of you said, a little under half of you said, bring it on. You have well-documented, thoughtful processes in place for your use of criminal history. That's super. About half of you probably said, you could probably use a little bit more documentation, a little bit, you know, a little better process. And certainly, I think the webinars we have on this topic would help you there. And some of you have a lot of work to do, and hopefully you'll attend those webinars or go look at them even sooner, the recorded versions on our website. The next area that makes it really difficult to be, especially if you're a multi-state employer, are that there are state and even local, municipal, and county level laws that affect what employers can do. These mostly focus on when you can ask an applicant about their criminal history. So it doesn't have anything to do with really the background check. It's about when you can inquire about their criminal history. There are also local ordinances about what you have to do when you're making an employment decision based on somebody's criminal history, about the process you have to follow, even down at the municipal level. And then credit is a hot issue too, and there are limitations both at the city level. The city of New York has the most, probably the most restrictive and perhaps burdensome law on the books nationwide for employers who want to use credit, but there are other places that have that as well. The good news is the majority of states and the majority of cities and counties don't have all these regulations on employers. So but that doesn't mean you don't want to have thoughtful processes. But you know, you do need to make sure that you're thinking through, especially if you're a multi-state employer, how you're dealing with that. And I'm curious. I know a lot of you are probably you know, located primarily in one area, but have you checked into any state or local issues concerning your use of criminal history in the locations where you're located? This stuff sneaks up on you, and it's been a really busy year in New York City. They've published, they've approved laws just for the city of New York concerning the use of credit and criminal history. And so we've got a couple clients with operations in New York City, and we've spent a good bit of time with them understanding what the ordinances or the city laws, local laws mean for them, and how they're going to comply. And it doesn't help that the New York City Commission on Human Rights kind of takes the EEOC's approach in saying, okay, this is what the law says, but this is what we really want you to do. And they add these new requirements in their legal enforcement guidance. And so then employers are left to decide, okay, the law says this, but the investigating agency wants us to also do this and this. What makes sense? And so employers have to make those decisions, you know, appropriate for their circumstances. But you really don't want those investigations if you can avoid them. So if you can tip your hat to them, you're probably better off. So you can see about 2/3 of you are aware of what any local rules are, and about 1/3 of you haven't. And I'm hoping that for you third that these aren't things that are going to bite you. But if you have specific questions, don't hesitate to give me a call. And we've got a whole webinar on, especially on the criminal history inquiry and what the state-specific and even municipal area concerns would be. So let's see what our next one is. Okay, the next thing you want to talk about, or you know, in your process is your employment application. So we've just talked about the legal stuff, but we haven't really talked about how we do anything. Well, your employment application needs to be really thorough. I see a lot of employment applications that are real basic. They don't have a lot of information for the applicant to provide, and it creates a low barrier to entry for applicants who you probably don't want. I would suggest that you want to always, in the areas surrounding employment history, always ask for them to list the skills that they developed in that job, what their accomplishments were, and pin them down on termination reasons. If they don't have that information, like the dates of employment, things like that, or a phone number for that employer, that should really be your applicant's job to go get that information for you. If they really want this job, then they'll go get it. If they don't go get it and they don't care about you know, being responsive to your questions, that's probably a really good behavioral technique to look into, to say, you know, is this a job that requires very much compliance? Is this a job that I need people who are going to do what we tell them to do, or who are going to do as little as they can do and get by? And, you know, I'm amazed sometimes at the applications I see that employers accept that have giant gaps in them and are empty and all of that. And even a lot of online employment applications allow employees to skip questions or to not accurately provide the information requested. And I suggest that you want that every time. If you're accepting paper applications still, I would suggest whoever accepts those applications looks at them every single time and make sure there are no blanks. There should be no blanks. At the minimum, they should write not applicable or not available, or give some explanation. But there ought not be any blanks on the employment application when it comes back in, because you're asking, hopefully, very legal questions of your applicants, and they should be responsive to that. And and maybe they're self-identifying to you as somebody who's not going to be a great employee if they won't do that for you. You can include a criminal history inquiry in the employment application. There are 65 million Americans, 1 in 4 adults, have some sort of criminal history. Now, there are groups out there like the National Employment Law Project and other groups like that that would suggest that means the 65 million Americans are unemployable. Employers won't hire them, and they automatically discriminate against them. Well, that's not the case. But you can use criminal history, but you need to use it correctly. You need to use it in a way that's legally compliant and that doesn't get in the way of you hiring really qualified employees. So some states will allow you to ask on the employment application about criminal history. There are a handful of states that will not allow you to do that. There are, and we've got a whole webinar just on criminal history inquiries that may be helpful. And certainly, now it's getting down to individual municipalities having issues, like New York City has banned the box. You can't ask about criminal history in New York City until after an offer's been made. San Francisco has its own rules as well about even what an employer can consider, what kind of criminal history an employer can consider. So, one of the big questions is, when can I ask? And so most states don't have any limitations, but some states say you can't ask until after somebody's been selected for an interview. Some states say you can ask at the interview. Some states say you can ask after the interview, and a few others say you can't ask until after a conditional offer of employment's been made. So you'll want to make sure, if you're a multi-state employer, that you're looking at those requirements for each of your locations. The other question is what do you ask about? The worst question you can ask, and the one I see most often, is, have you been convicted of a felony in the last 7 years? That's a really bad question. There are a lot of misdemeanors that you care about as an employer, and so by ignoring those, you're giving the applicant opportunity to answer honestly no, even though they were convicted of several misdemeanors. That would be a red flag for you. And limiting it to 7 years, except in a couple states, doesn't make sense either. If somebody was convicted of sexual assault 8 years ago, and you ask if you've been convicted of a felony in the last 7 years, I would suggest that you probably care about that. So why are you limiting your information to 7 years? There are a lot of different things. We offer our clients a sample criminal history inquiry that's very thorough, leaves no wiggle room for the applicant, and then we can tailor it state by state to meet specific requirements and limitations in the handful of states that have those. So, the great thing about having it as a separate document, as apart from your employment application, is that ban the box, this movement to move the criminal history off the employment application, is gaining ground. And so, if you've got a whole bunch of employment applications printed up, you may have just throw them all away if you've got a criminal history question on there. Whereas if it's a separate document, you can insert it into your process whenever it's appropriate. Now, Title VII and the EEOC come into play with this idea of individualized assessment. This is the concept that you need to give the applicant an opportunity to explain why your policy, your criminal history policy, shouldn't apply to them. Okay, that's not in Title VII. There's no case law that suggests that. This is something the EEOC came out with in a 2012 guidance document, but quite honestly, it's not in the law. However, you don't want to tick off the EEOC. I mean, if you get some sort of complaint, it's better that you've tipped your hat to the things they want you to do rather than just totally ignored them. So what we're doing with our criminal history inquiry that we give our clients, we give them an opportunity right there on the criminal history inquiry for the applicant to provide their individualized assessment information about that they think help you put into context their criminal history information. So it may be, you know, I was a dumb kid. These are things I learned there. This was 10 years ago, and in that time subsequent to that, I've not had any other criminal history, and I've completed college, and I've done this and this and this. Things that may make, you know, make it, you know, give you more context in making a decision as to this person's fitness for the position. And so we've built that right into our criminal history inquiry that we share with our clients. The consumer report disclosure form is really important because you want to make sure that you're getting your applicant's legal authorization to procure the background check. Most employers are still collecting this right up front at the application point, and there's no reason not to, quite honestly. Go ahead and get their authorization right up front. Now, this document often has date of birth and social security number, things like that, that you may not ask on your employment application. And so you want to keep this document separate from the rest of the employment application if you're collecting it via paper. But if it's electronic, of course, it's less of a problem. But if you might as well get it up front. Otherwise, what we find with clients who wait till later in the process to make the disclosure and make the authorization that's required under the FCRA is that it delays their process. They're ready to move forward with this guy. They want to order the background check, but now I've got to send them this form, or I've got to get them to go online and give us the authorization. And you may lose a day or two. And maybe we found that sometimes applicants just aren't good at reading their email or responding as timely, even if they want the job. So we're still recommending most of our clients do the FCRA disclosure and authorization up front early in their process, and you've got it in a file if you ever need it. We'll get into the details of what the law requires in our FCRA webinar later on this year, but hopefully, you know, you've got your ducks in a row there. But if you have questions about any of that, please don't hesitate to give me a call. So the applicant gives you the employment application. Maybe they've responded to the criminal history inquiry, and you've got their authorization and disclosure to order the background check. Before you do anything, review all of that information. We see applicants who give one social security number on the employment application and a completely different one on the background check form. We see non-responses where people don't either skip fields or just don't answer questions, or they write "will discuss." And to me, especially if we're looking at employment termination reasons or criminal history questions, "will discuss" means no, we won't, because if you're asking a legal question under state and federal law, there's no reason that applicant should do anything but give you a correct and full answer. And if they're not doing that, what does that tell you about how what their performance is going to be like on the job? I mean, they're self-identifying to you as somebody who's going to maybe be evasive or not as upfront and straightforward with you. So we really recommend that you get all this paperwork, and whether it's paper, electronic, or whatever, and go through the process carefully and read through it. A lot of, in the handoff sometimes from maybe recruiter to HR, nobody ever really looks at all of this information. And so now you got maybe an HR generalist who's responsible for onboarding this person, and they're assuming the recruiter did all the work, right? And the recruiters may be assuming that, well, HR or the generalist or whoever will read all the details in the application, or leave it up to the hiring manager, who's probably the last person in the world that you want to spending a lot of time doing that. The next thing you want to do is, okay, we're going to review this. Well, they identified criminal history information to us. So what does it tell us about this applicant? Well, are they eligible? Just because they had a criminal history, we're not going to eliminate them, but we're going to look at the offense, and we're going to look at those tools we talked about earlier and say, yes, this person's eligible for hire. This one offense in and of itself wouldn't disqualify them. Or this one offense in and of itself within the last 3 years or 7 years or whatever is a concern. Doesn't eliminate them necessarily, but we're going to have some sort of management review. We're going to look at the entire applicant, everything they bring to the table, along with the rest of the applicant pool, and make a hiring decision. And then there are going to be some where they're just not eligible for hire. This role has access to vulnerable populations, and so if you've got a sexual assault conviction in the last 10 years, you're not eligible for this job, and it's just a flat not eligible. That should be pretty limited in how you do it, but there are going to be such situations where that's perfectly reasonable. And so reviewing all that information, I can't tell you often we've done a background check for a client, sent them back the person's history, and it's something that would disqualify the applicant from consideration. And in my conversations with the employer afterwards, they say, "Oh yeah, looking at the application now, yeah, he told me that. He put that on the application." But nobody ever really paid attention to it and they still wasted the money on the background check when they knew the information right up front on the application. So you really want to look at all that information before you go to next steps. Make sure that they're really eligible to work with you. And so this is what that offense matrix kind of looks like. And you can see assault, bodily injury, assault, battery, domestic violence, misdemeanors. This person, for this position, whatever the position, sample position, it's a C. It's a corporate review for the last 7 years. So they've got an assault conviction in the last 7 years. Yeah, we're going to be concerned about it. We're going to look at it, but it doesn't necessarily eliminate them. But more than 7 years, you see, yes, they're eligible. If that's all they've got, and in and of itself, it's eligible. But for this particular position, child neglect or child endangerment in the last 3 years would make them no, they're not eligible. And so you see how that would kind of work. And once you've got a tool like this, you can very quickly move through the hiring, the process for determining whether they're eligible, and you can move forward with them to a next step. So now the next step you really want to do is verify everything that they've told you. Believe me, I would be out of work if all the applicants were honest, okay? And so sometimes the most convincing applicant, the most charming and the most seemingly qualified is the one with the biggest time bomb in their background. I hear from employers all the time, well, I have a hard time believing this because he was so charming in the interview, or he's such a good engineer. Well, he can be a good engineer and still be somebody who you don't want in your environment, and somebody who lied to you on the employment application. So look at your employment application as the least expensive integrity test you will ever give this applicant. It costs you a lot less to give them opportunity to lie to you up front than giving them opportunity in a very uncontrolled setting down the road to cause damage to your organization by not being straight with you or committing some sort of criminal act. So we really think that, and you'll notice everything up to this point has been on the employer. This is not stuff that Imperative really even necessarily sells. This is stuff that we think that our clients would benefit from by just implementing these kind of processes in place. But you do want to verify everything the applicant tells you. And so let's get real quick into the background check process. What goes into a background check, and where does this information really come from? Well, quite honestly, what we're going to start with is, again, what the applicant told us. We're going to start with their name, date of birth, social security number, address history, anything that they've given you. And then we're going to bounce some of that information against a database that has all kinds of records in it, from credit bureaus, from consumer reference files, everything from magazine subscriptions to other information like driver's license files. You've heard of big data. Well, this is big data. This is what we're talking about. And what we'll hit this database, and what it really tells me is, are the names associated with that person's social security number? And that matters on two fronts. If your applicant is John Smith and all the information we get from the identity research comes back as Betty Jones, we've got a red flag here. Maybe the social security number was entered accidentally wrong, you transpose two numbers, or the applicant is outright trying to use somebody else's information. We see this certainly with undocumented workers, but we also see it with people who are legal to work in the U.S., but what they're trying to do is avoid maybe some sort of government penalty. Maybe they owe child support, and they know if they give the employer the right Social Security number, that employer is going to report them in new hire reporting to the state attorney general, who is going to levy against their wages to collect child support, and they don't want that, and we see that quite a bit. So it's important that those that we try to verify that this person's Social Security really, or at least corroborate that this person's Social Security number really belongs to them. We're also going to see other names associated with them. So maybe Betty Smith used to be Betty Jones. If all her criminal records are under Betty Jones and she doesn't tell you she used to be Betty Jones, then we won't find those records because all the court's records are indexed under the person's actual name. So if we're only searching Betty Smith, we're not going to find those Betty Jones cases. We'll also verify that the Social Security number is issued. In most cases, they randomized the issuance of Social Security numbers a few years ago, but right now we still, on probably 95% of our applicants, we're still able to verify when it was issued and that it was issued, especially as a big red flag, if the Social Security number was issued before the person was born. And we see that from time to time. And then we get a good address history, and the address history tells us where to go do research on this person. These are, these are addresses associated with their credit card history, other kinds of loans that they've had, and again, other kind of consumer reference information that's not directly credit related, but comes from any number of sources that that are somewhat reliable. Now, Comparative doesn't turn that address history information over to our clients, primarily because I can't defend the information that's in that. This is a database that's got records from dozens of sources, and it's full of errors. My address history when I run my own report shows a P.O. Box number 1, Fort Worth, Texas. Well, I've never used P.O. Box number 1, Fort Worth, Texas. I think the mayor gets that. I don't know who gets that, but it's not me. But so you see things like that. You may also see something like different spellings of names that show up. If a clerk at JCPenney's is inputting a credit card app there at the register and types the name in wrong, boom, it goes out to the credit bureau and gets disseminated to the whole world. And so those kind of issues show up. So we don't even give our clients that. We just use it internally for research, and we've got our own rubrics about determining when a name variation is valid and what addresses we use to conduct research. Another great tool to verify identity is a driving record. Now, even if you're not concerned about the person's driving history, if you've got the driver's license number and we verify that information is accurate, what we get back is that person's legal name as far as the Department of Public Safety or the DMV is concerned, and a good address as far as what the state thinks their address is. And so that's a good way to verify that name, date of birth, and address you've been provided do line up with the state's official record. And then, of course, you want to do employment and education verifications. These are high areas of fraud. We see as more fraud, more people lie about their education and employment history than they do about their criminal history. This has really gotten bad since about 2008 when the economy fell apart. But we regularly catch people who claim to have worked places that they never worked, or they mess with the dates of employment to cover up gaps in their unemployment period. People claim self-employment sometimes where they really never were self-employed, and there are ways to do that. We can help a client figure some of that out as well. But verifying their references or their employment history and their education, we see a lot of fraud in the education area, is really important as well. And you can, there are schools that will verify, they're fake schools, they're degree mills, and they've got a website and it looks like, oh wow, it's a beautiful place, I'd love my kids to go there. And you call the phone number to verify the degree, and the registrar answers the phone, and she's real friendly and helpful, and you would think you were talking to a real institution. And they don't have a classroom one, they don't have any real students, you just pay for the degree online. And in Texas and a few other states, it's illegal to apply for a job with a degree from an institution identified as a degree mill, but we still see it all the time. Now, credit, that's a hot issue. It's under pretty significant scrutiny by the EEOC and a lot of states. And New York City, I just spoke about them earlier, they passed a Stop Discrimination, Credit Discrimination in Employment or something like that act earlier this year, and it went into effect last week. and the use of credit is really problematic. And I spend most of my time, quite honestly, trying to talk employers out of using credit, because it doesn't tell the story you think it tells. Whenever I talk to an employer and they say, well, this person handles cash, and so we want to make sure that they've got good credit, because if they got bad credit, they're more likely to steal. Well, it's probably not true. The few studies that are out there show no correlation between a negative credit history and the likelihood of dishonest activity, theft, or even having performance issues. In fact, you may be more concerned about the employee, the low to middle waged employee who's driving a brand new BMW and has stellar credit. That may be a bigger issue for you, to be honest, especially if you have easily removable assets. But the only time we ever recommend clients really look at credit is when somebody is going to be making significant financial decisions on behalf of the employer or their clients. So your investment advisors, certainly FINRA is going to expect you to do that, and that's a smart thing to do. Your CFO, CEO, C-level candidates or employees, you want to make sure that you look at that, because it may be instructive about how they may manage your own business. But for most people in most positions, credit just doesn't tell the story you think it tells. And then there's references. And I'm not talking about calling HR and verifying dates of employment and that kind of thing. I'm talking about talking to former supervisors or coworkers or people that the applicant listed as personal references. I don't know how many of you actually do personal references, but really that's an intelligence test. Is this person smart enough to list 3 people who will say nice things about them? The truth is every now and then when we do these, we have clients who have governed by regulatory agencies that require references be checked, and so we do it for them. And every now and then we'll talk to somebody and they'll say, he listed me, and then they'll throw him into the bus. And even if that person's totally biased, we might have just learned something about the applicant that they're not even smart enough to prepare this in advance before listing people as a reference. But you know, we really think unless you've got a legal obligation to do it or some sort of contractual obligation, references are probably one of the things you get the least real value out of. But you know, like I say, every now and then you'll find something that might be helpful. We even get people who list former supervisors, and we'll call the former supervisor for a verification or a referral, a reference, and we start talking to them, and we just get a little liver quiver. Something doesn't seem right. It's a cell phone. Maybe the guy says he doesn't work there anymore, but he's remembers our applicant and how wonderful he was and all that, and something just doesn't seem right. And so we turn around and we call HR at that company, and they've never heard of our applicant or that so-called former manager. And so we see a lot of people who try to get kind of clever with how they do that. So really, how do you know that this person, this reference you're calling, was that guy's former supervisor, or that it was a colleague that they worked with? If they say, well, yeah, I worked with him, but I'm no longer there, how do you really know that you're even getting information that's accurate? Then there's civil litigation, and this is a hot area for our clients who are hiring upper-level, C-level people, or again, people in financial industries, things like that. Who have they sued? Who sued them? That's kind of basically the civil litigation thing. Now, it's a lot more expensive to do civil litigation because the research is much more involved, and to really understand what the case was about and the circumstances surrounding it, you really need to do some additional research. But especially for your upper-level positions, that probably makes sense. So what's the one thing we haven't talked about so far? Well, that's criminal information, right? And that's what most people think about when we say criminal history or background check. They think about criminal history or credit. So first thing I want to suggest is forget everything you've seen on CSI. This is not TV. That's fiction. Okay. The idea that there's a central database out there that's got everybody's criminal history and including, you know, and everything else about who their college roommates were and who their 5th grade math teacher was, all this stuff. It just doesn't exist. I used to be worried about Big Brother, and I'm really not anymore after having worked with the government's records for the last 16 years. But the FBI does have a single database of criminal records, but it's just not very comprehensive. According to the U.S. Attorney General in 2006, half of the FBI's records were incomplete, and they were missing an unknown number of records because they knew the states don't give them all the information. So if you're in one of those very limited banks and a few other industries where you can actually get FBI fingerprint searches, I recommend that you go ahead and do them. However, you've just got to realize that you're very likely going to miss a lot of records if you're relying just on the FBI's database. Now, it's as a single source of information, it is the best information you can get. It's better than any like instant database over the internet or anything like that. But it really should just be one piece of your whole criminal background check process if you even have legal access to it, and most employers don't. Most states have some sort of statewide criminal record repository. In Texas, we ran everybody on death row a few years ago through the Texas DPS criminal records database. And we found that a third of the people on death row were missing from Texas's statewide criminal records database. And that matches what we also found when we looked at 500 other cases that we found at our local courthouses and checked them against DPS. We found, in fact, that was the same situation. No matter whether it was a misdemeanor or a felony, a third of the records we found in the courthouses were not at the state criminal records repository. And then there are companies that sell nationwide or national comprehensive criminal background checks. These are usually instant databases that get delivered over the internet. Our experience is that, again, they miss about half of the records because there are a ton of states and jurisdictions, even local counties, that will not make their data available for bulk purchase electronically. So, because what these companies do, these so-called national criminal database companies, what they do is they buy the data from those jurisdictions that'll sell it, and they shoehorn it all into a single database. But there are a lot of problems with that. Comfort Keepers is an international franchise. They provide non-medical in-home care. Think about basically non-medical sitters. And so if you've got somebody recovering from a fall or something like that, and they just need some light help around the house, cleaning, maybe preparing meals and things like that, and just checking in on people, that's what Comfort Keepers does. Well, they hired this guy, Michael Gilbert. He's a registered sex offender convicted in the 1987 aggravated sexual assault of a child. It was a 12-year-old female. He was released from parole for that offense in August of 2005. At that time, he was also on federal parole for issuing false distress signals at sea. He tried to fake his own death at sea to get away from his sex offender registration obligations, thinking that maybe if everybody thought he was dead, he could move on about his life. That didn't work. So he was on federal parole. He'd just been released from parole for a sexual assault case, and he was in August 2005. He was hired by Comfort Keepers as a sitter in October of 2005. They ran a so-called national criminal background check on it, and it came back clear, even though he had a federal conviction and he was a registered sex offender. Within a month of his hire, actually about 2 weeks of his hire, he had allegedly sexually harassed an Alzheimer's patient, a female Alzheimer's patient, a 77-year-old woman who was residing in the facility he had been assigned to sit with another patient. The sad thing there was because she was an Alzheimer's patient and she wasn't, they couldn't put her on the stand. She identified him, and then when the police ran his background and found all the history, they were quite certain it was him, but they couldn't prosecute. There's a civil case resulting from it, by her family, and everybody settled. It was it's a no-brainer to settle that case. I've been talking about this guy since 2005, and using this photo in my presentations, And so imagine my surprise in 2011 when this picture showed up on the front page of the Fort Worth Star-Telegram, my hometown. And he again had been arrested for trying to, had been investigated for another sexual assault case, and he tried to fake his own death again. This time he kidnapped a homeless person and killed them, and then burned his car with that person in it, trying to demonstrate, make the police think that it was him who died in the car fire. And so this is a bad guy, and it's probably not who you want, but at least in 2005, his so-called National Criminal Database record was clear. The other problem with these databases is they're just a snapshot in time. So if a record changes, it doesn't always get updated. Entre Knox Courage was convicted in 1997 of murdering his girlfriend, and he received a life sentence here in Texas. In 2005, the Innocence Project proved through DNA that he was not guilty. And Governor Rick Perry here in Texas pardoned him as actually innocent. Now, Rick Perry was a lot of things, but he was not a soft on crime governor. And if he said somebody was actually innocent, you can take that to the bank. And in January of 2006, Entre Courage's criminal history in Dallas County was completely wiped out. It was expunged. It no longer exists. And 2 years later, though, he had landed a job as a security guard at a bank. And again, this is a guy who really had no criminal offenses. He landed a job as a security guard at a bank. They ran the background check after they hired him, which is a bad idea, especially with the security guard, but they did. And the database report that they ran, the instant criminal report, showed his murder conviction. They fired him. He turned around and sued everybody. Everybody settled. So, and I'm less worried about you getting sued. I'm just more worried about you missing out on good applicants because the information is incorrect. Another problem with the criminal database is that they miss active or pending cases because they're a snapshot in time. They usually only show convictions or maybe deferred adjudications. And so if somebody's got an active case, it doesn't show up, and that's probably something you'd like to know about. So how do you do it? Where do you get good information? Well, you have to go into the courts and check the live records in the courthouses where the person's lived, worked, attended school, typically for the last 10 years at a minimum. And so that means if they live here in Fort Worth, where I live, you go to Tarrant County. If they live down in Laredo, you go to Webb County. In Austin, you go to Travis County. Los Angeles, you go to Los Angeles County. Las Vegas, you go to Clark County. You go to and check the live records in those counties where they've lived, worked, attended school. That's really the only way to do it well. Then there's a whole nother set of criminal records called the federal courts, and those are records of violations of federal crime. And only about a little over 2% of the criminal records that we report to our clients come out of the federal courts. There's just a lot fewer of them, but it's always something you care about. Kidnapping, interstate drug crimes, child pornography, wire fraud, bank robbery. These are all things that you probably care about for most of your positions. And searching the county records or these instant databases will miss the federal court cases. So you want to make sure you're looking into those as well. So what does a good background check start with? Look like? It starts with that identity research and then goes to those state and national databases. And we use those state databases, and we even run on every report a national database. Our clients will never see the results of it. What we do is we go verify it at the county. So if it says there was a record out of, Maricopa County, Arizona, we'll go to Maricopa County, Arizona and verify it, or DeKalb County, Georgia, you name it. We'll go verify those records. And then you also want to do county research in all the jurisdictions that are associated with that person and all the places where they've lived, worked, attended school for the last 10 years. Now, you have to really do that ID research, though, because, of course, if they know they've got a record in San Antonio, Texas, they're not going to mention that to you. And so hopefully their address history will show that they live there, and we'll go do the research and find the record that way. And then you want to do the federal court research as well. You want to verify that they don't have any cases in the federal courts. This is what we call a critical criminal background check. This is a really thorough criminal background check. and then all of that, of course, goes into the report. Now, the thing I really want to stress is all the background check is going to do is catch the low-hanging fruit. The people who've been caught previously, either by an employer for being a knucklehead or by the law enforcement for being a criminal offender. There are a lot of people out there who are doing bad things and they haven't been caught, or they just haven't had the right opportunity to do something bad, and you don't want to give that to them. So you want to make sure all your other business controls are in place. That means if you're working with children or the infirm or vulnerable populations, you have really good sex abuse awareness training in place and good policies that make sure that everybody gets trained well. We partner with a company called Ministry Safe that helps churches and nonprofits across the country put safety and abuse prevention systems in place for those kinds of things. But if you've got, if you're just a regular company, you don't have those kind of things, you still need your financial controls in place. I see so many cases where somebody with signing authority didn't have a check and balance system in place, and they stole a lot of money from their employer. So you want to have all your controls need to be in place. And when the background check comes back, you want to first look at that criminal history information and see what your own policies say about the information that that came back on the background check. Look at the application. Did they tell me the truth? Was the information in the report, does it match what they told you on the application? If not, did they lie on the application? That may be a disqualifier right there. But maybe you didn't ask a thorough question and the information came back. You look at your policy and see if this would eliminate them. And then if you decide it may eliminate them, or you're gonna offer them a different job, or you're going to offer them different pay based on their total history, whether it's employment or whatever, that's where the Fair Credit Reporting Act's adverse action process kicks in. And so you want to make sure that you follow the adverse action process if you may take an adverse action. And basically, in short, and again, we've got a whole webinar on this topic, that means you give them a copy of their report and their rights under the law before you take the adverse action. I've just spoke to an employer this morning, a very large employer with operations in all 50 states. It's one of our clients, and unfortunately, their local manager found out that the criminal background check was back, and that this guy had some records that were going to eliminate him. And before the applicant had an opportunity to receive their report and their rights under the law, the employer picked up the phone and told the applicant, hey, we can't hire you because of your criminal history, so we're moving on to the next applicant. Don't do that. That's not what you want to do. Before you make the decision, before you put it into effect anyway, before you tell them you're not going to hire them or before you hire a different person, make sure they get a copy of their rights and a copy of their report. That's just what the law requires. And then there's a cover, a cover letter that you probably want to send when you're providing them this. And that cover letter just says, here's why we're giving you this information. Insert in there, we recommend you insert in there, again, that individualized assessment information that we talked about over when we were talking about the EEOC and Title VII stuff. Why not give them an opportunity right up front to say, hey, if there's additional information that you think will help us put this all in context, give it to us in writing. We'd love to have, we'd love to review it in full. Maybe it makes a difference, maybe it doesn't. But at the very least, you're complying with what the EEOC wants you to do, and you can point to it as a compliance tool if you ever get a accusation that you didn't that you were creating a disparate impact on somebody in a protected class. And then you want to take a breath, okay? And give the consumer, when you've made that pre-adverse action copy, make sure that the consumer has an opportunity to look at it, and then let them, if they say it's inaccurate, refer them back to the background screening company. If the information is inaccurate on the report, you don't have a responsibility as the employer to figure out if it's right or wrong. That's the background screening company's responsibility. We have 30 days under the federal law to reinvestigate that. And I'll tell you, if you're working with a really good background screening company, you should get, just a handful of disputes ever. And even fewer of those disputes should result in something actually being changed on the report. We've changed 3 reports in the last 5 years. It should be very rare. In fact, if you're seeing a lot of disputes that result in your reports being changed, that's a big red flag that you may end up in litigation. So you want to be really careful. And then once, here's another instance, sometimes when the applicant says it's not me, it really isn't them. And we don't have time to get into all the story, but it'll be in the notes and the slides I share with you. But this is a story that where, and it's also on our website, where the applicant was truly had somebody else had used their identity to commit crimes and actually even served jail time under their identity. And the applicant was unaware of it until our background check came back. And so it can happen. It's really, really rare, but it can happen. And criminal identity theft is becoming more prevalent in criminal history in records. And then finally, after you've given applicants received that information, had a chance to review it, you can make the decision, okay, we're not going to hire you. And then you have to give them a second notice saying, we're not going to hire you. This decision was based in whole or part on the background check, on the consumer report. This is how you contact the background screening company if you want to punch somebody in the nose or dispute the information. The background screening company didn't have any role in making the decision. They just provided the information. There's specific things that this correspondence has, and our online system will deliver it to you, and most background screening companies that can deliver this electronically on your behalf. So that is the 1-hour high-level review of these 6 webinars. And we're going to get into each of these, September, October, November, a couple times, December and January. These are all things that are covered in more depth in our upcoming webinars. We are right at 2 o'clock. So we're going to go straight to questions. And I want to answer your questions if I can. So let's see, we got quite a few of them here. We will be sending the slides out later this afternoon. What you're going to get are a slide deck with all the notes. Not because, as you'll probably realize, as most of my slides are pictures, but there are notes for each slide that'll hopefully be helpful. And you'll also get the HRCI and SHRM as continuing education information, recertification information. What we'll do is we'll send you an email, and it'll be sent through SurveyMonkey. So you do the SurveyMonkey, and you do our little survey, tell me how I did, where I need to improve, whatever. Then we'll, at the end of the survey, you'll get the HRCI information. The survey doesn't cost you anything, just takes, just maybe 2 minutes, but that way we get some feedback from you, and you get the HRCI information. So let's see. I'm reading these notes. Okay. How do you recommend assessing past convictions regardless of time passed or connection to position that go against the values of the company? No is no. Does a company have to have a value statement documented to support these decisions? Well, I would argue that forever should never be forever for most offenses. So even if you've got, and I applaud you for having a good company value system, we have one here, but something that somebody did 15 years ago may not be reflective of who they are today, depending on the offense. So I would suggest that you use the rest of your employment process to measure values, unless it's a really recent criminal history. I mean, if honesty, integrity are core values of your organization, and somebody's got a number of theft cases or perjury cases, things like that, and they're fairly recent, then that's 5 to 7 years. That's probably something that you can use as a red flag. But I'd be really cautious in just saying that somebody's criminal history, one offense 8 or 10 years ago is really reflective of this person's values or how they're going to fit in your organization. I think I'd be a lot more nuanced than that. And as you're a client, I'm not going to mention your name, I'd love to talk to you more about that, and we can maybe work some of that out. What is your advice for employers who run the background check during the employee's first week at work? My advice would be don't do that unless you almost never get criminal records on your employees and never have to take an employment action, because legally it's fine, but it's a real hassle and uncomfortable for a lot of people to have to walk somebody out because they failed a background check. And if you've got a good process up front that asks a legally compliant criminal history question, and they told you the truth, then you shouldn't have any issues. But if they lied to you, that means they're low integrity, and you've just given them access to your organization for a full week. And so if they've got access to your computer network or to your client database or anything like that, and they lied to you on the application, can you be surprised if they take other advantages of you, even in a week? So I would rather wait. I'd rather do it before employment begins. You can always make a contingent hire saying, we're offering, today is Tuesday and we're going to offer you the job effective starting next Monday, but that offer is contingent on the successful completion of the employment background check. Even ask them, are you sure there's nothing else that's going to come up, because we don't want any surprises in this process. You'd be surprised just by asking that question how often applicants will come back and say, oh, well, this might show up. And then you have to decide if they lied to you on the application earlier, because certainly if you've got a good question, they probably should have told you earlier in the process. Let me see what else. Okay, it looks like that's the last question. Let me jump back to this series of webinar slides. But if there are no more questions, then I just want to say again how much I appreciate everybody being on the line, and I hope this was time well spent. If it's not, tell me, quite honestly, during the webinar process or during the survey process. I really do covet your feedback. And we will otherwise go from there. I appreciate everybody. And again, of course, if you don't absolutely love your current background screening partner, I would love an opportunity to talk to you about how Imperative can work with you. The level of consulting and assistance that we give our clients, I think, is better than anything else out there in the industry. And that's why we have clients who never leave. And we had, in the last 4 or 5 years, we've had 2 really large clients who had to leave because of budget purposes. The CFO said, you got to cut your cost per hire by X, and the only way they saw to do that was to do it by cutting their background screening process to a less expensive background check, and really just a cheap, instant kind of product. And they've both come back to us. And first of all, it's very flattering that they came back, but they had a lot of headaches in the meantime, and it was really expensive for them. So, we're not the least expensive option. We don't respond to RFPs because of that, because those almost always go to the low bidder. But if you need consulting, you need somebody who's got your back and is going to make sure that everything we give you is actionable and accurate, we'd love to talk to you. That's where we focus on, is getting it to you in a really reasonable amount of time, at a fair price and a reasonable price, but it's going to be right. And we never want to have to tell our clients we're sorry. And so we bend over backwards to make sure everything is accurate. So thank you to everybody for being on the call. And if I can be of any service, don't ever hesitate to give me a call. Thanks a lot. Bye-bye.